In cause number 26, DCCR 0908, you're charged with a second-degree felony offense of robbery, and that's from February 12th of 2020. And how do you plead to that charge? In all three of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1.
Which one did y'all put it on?
Good morning. Are you Brendan Ernest? And Mr. Rojas, will your client waive the formal reading of the indictment in each case?
He will, Your Honor.
All right, Mr. Ernest, in cause number 26, DCCR 0429, you're charged with the first-degree felony offense of aggravated robbery, and that's from February 20th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? In cause number 26, DCCR 0430, you're charged with a third-degree felony offense of obstruction or retaliation from February 12th of 2026. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily, and because you did what they've charged you with? In cause number 26, DCCR 0908, you're charged with a second-degree felony offense of robbery, and that's from February 12th of 2020. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? In all three of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? So you can't change your mind if I follow the agreement. You understand? And it looks like the agreement that you've reached in all of these cases would be for 10-year deferred probations. There would be $500 fines in each case. There would be a dismissal in cause number 26, DCCR 0431, and you would be required to follow all the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Ernest is not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas. Find sufficient evidence to find you guilty in each case, but I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we'll come back later for sentencing. Yeah. All right, you can go back with the bailiff. All right, 23 DCCR 0319 on Lupe Gomez. I've got Mr. Nichols here for the state. Mr. Radford is here. Sir, you Lupe Gomez.
I'm sorry?
Is your name Lupe Gomez?
I'm the non-quoted
What?
third-party intervener, cross-plaintiff, superior lien holder, to give our special restricted visitation and not of general appearance.
Can you do this? Can you come around and have them so I can see better?
You want us all to bench up?
Yeah, y'all can all come up here. Okay.
So I have a couple questions.
No, well, hold on. You don't get to ask questions. I'm going to ask the questions. Mr. Gomez.
Can happen until all parties are identified into the record.
All right. So, Mr. Tell me again who you are. Who are you saying you are?
I'm a non-corporate third-party intervener, here by special restricted visitation and not by general appearance, under duress by the means of threat, coercion, and kidnapping.
Okay. Have you ever been known by the name of, in the past, Lupe Gomez?
Will you state your name for the record, please? And will you order the prosecutor to state his name for the record? And do either one of you have a claim against me?
We do have a claim against you. My name is Raquel West. I'm the judge of the 252nd District Court. This is Mr. Luke Nichols. He's one of the assistant district attorneys in my court. Mr. Radford is here representing you.
Okay.
There's an indictment. There's a motion to quash. Mr. Radford has filed that we're here for today. I'm going to take judicial notice of the court's file, which includes numerous documents, including a indictment, the probable cause affidavit, other identifying information that does identify you as Mr. Lupe Gomez. And I'm going to make the finding at this time that you are, for purposes of this hearing, Lupe Florencio Gomez. And we're going to go forward with the motion to quash.
That's a motion to suppress it.
Motion to suppress. I'm sorry. Let me get that pulled up. I have a motion to quash as well, correct?
Yes, you do.
Hold on.
I think that's a pro se motion.
Pro se motion.
Okay, so we're here on Mr. Radford's motion to suppress. Let me find that one. It's okay. I'm looking.
Well, while you're doing that.
Nope, stop talking.
Onto the record.
Stop talking.
Your foreign agents and registration statement.
My what?
Are you refusing to do so?
I am.
Okay.
Here we go. All right, so Mr. Radford filed, it's entitled Motion to Quash and or Suppress Evidence.
Oh, okay.
And that's why I was confused because it just showed the first part. And 23 DCCR 0319, this was filed April 29th of 2024. And Mr. Nichols, you may call your first witness with regard to the suppression.
State House Officer Chad Morrison.
Would you please call the name?
Officer Chad Morrison. No response, Your Honor.
All right, Mr. Nichols?
Your Honor, I have no other witnesses, and this time for this hearing, the state rests. May I make a statement on the record?
Yes, you may.
Your Honor, I was in contact with Officer Morrison last week. He is formerly of Port Arthur Police Department. He now is with a different agency in the greater Houston area. He indicated he is on injury leave at the moment and would not be appearing for this hearing. He was also on injury leave and was unable to appear last time we were set for this hearing, approximately 2 months ago, maybe in May. So that at this point, the state has no other option but to rest in this hearing and present no other evidence.
All right, anything?
This is the moment every courtroom watcher has been waiting for. The prosecution has officially rested its case without presenting a single witness or piece of evidence to support its position. In criminal court, that's a massive problem. No matter how strong the allegations may have seemed at the beginning, the burden of proof always stays with the state, and if it can't back up its case, the judge can't simply fill in the...
Anything, Mr. Radford?
No, ma'am.
Well, based on that, then, unfortunately, I have no choice at this point, which is unfortunate that the officer won't comply with showing up, but I'm going to grant the motion to suppress evidence in the case based on the fact that there's no evidence today presented. Is there anything else, Mr. Radford?
I would ask that the court dismiss the case, but I think Mr. Nichols is already preparing that.
I'll tender dismissal to the court, Your Honor.
All right, Mr. Gomez, I have granted Mr. Radford's motion to suppress because the officer didn't show up. What that means is there's obviously no evidence that would be able to be presented in your case. Mr. Nichols, it looks like, is going to present a dismissal based on the fact that there won't be any evidence, and I'm going to sign that. Your case will be dismissed.
Okay.
You can go back with the bailiff.
The bond money, being that the case has been dismissed, the bond money was to be returned.
Did you pay a cash
I
bond?
paid cash, $5,000.
But you're back in custody.
You're right. I still pay. The case is this.
Yeah, that you can take that up with the district clerk once you're released. All right?
May I be excused, sir?
Yes, if you'll...
What a dramatic ending. After all the unusual exchanges about identity and courtroom authority, the case ultimately didn't end because of those arguments. It ended because the prosecution couldn't present the evidence it needed. It's a powerful reminder that courtroom outcomes often hinge on procedure just as much as the facts themselves.